What happens after a lawsuit reaches the end of the appeals process? And what does it tell us about the American legal system when a case that has lasted for years finally reaches its last procedural stage? Over the past several years, one of the most closely watched civil cases in the United States has moved through nearly every level of the federal court system. It has generated intense political debate, extensive media coverage, and sharply divided public opinion. But beneath the headlines lies a broader legal question. How does the American civil justice system enforce a judgment after every major appeal has been exhausted? That question has become especially relevant following a series of recent court filings related to the civil litigation between writer Jean Carroll and President Donald Trump. The legal dispute has produced multiple jury verdicts, numerous post-trial motions, and repeated appellate review. Regardless of political opinion, the case has become an important example of how federal civil litigation proceeds through the courts, how judgments are challenged, and how enforcement mechanisms operate once appellate options become increasingly limited. To understand why the latest filings have attracted so much attention, it helps to step back and look at the broader process. Civil litigation in the United States rarely ends when a jury announces its verdict. Either side may file post-trial motions. Appeals can move through multiple levels of federal courts. During that time, enforcement of monetary judgments may be delayed while legal procedures continue. Those procedures are designed to ensure that both sides receive full appellate review before a judgment becomes final. Only after those legal avenues have largely been exhausted does the focus shift from determining liability to enforcing the court's decision. That transition from litigation to enforcement is often less dramatic than the trial itself. Yet in many cases, it is one of the most significant stages of the entire legal process. Because at that point, the legal system is no longer debating what happened. Instead, it is determining how a final judgment should be carried out under existing procedural rules. Recent filings have therefore drawn attention not simply because of the amount of money involved, but because they illustrate how federal courts handle the final phase of complex civil litigation. Questions surrounding escrow accounts, appellate timelines, procedural motions, and enforcement orders may sound highly technical. However, these mechanisms exist in thousands of civil cases across the United States. The difference here is the public profile of the parties involved. Whenever litigation involves a current or former president, routine procedural steps inevitably receive extraordinary public attention. That creates a second story alongside the legal one. Court filings become political headlines. Procedural disputes become public debates. And legal terminology is often interpreted through a political lens rather than a procedural one. For that reason, separating legal procedure from political commentary has become increasingly difficult. Yet understanding the legal process itself remains essential. Because regardless of who the parties are, the courts continue to operate according to established procedural rules, appellate standards, and judicial precedent. The latest filings therefore raise broader questions that extend beyond any single lawsuit. How quickly should judgments be enforced after appeals conclude? What discretion do federal judges possess when supervising enforcement? How do courts balance procedural fairness with the need for finality? Those questions affect far more than one high-profile case. They reflect the way the American civil justice system attempts to balance due process with judicial efficiency. And they help explain why legal observers continue to monitor each new filing so closely. The story, in other words, is no longer only about the original verdict. It has become a closer examination of how the legal system functions after years of litigation finally approach their conclusion. The latest stage of this case also illustrates something that legal scholars often emphasize but the public rarely notices. A lawsuit does not truly end when a verdict is announced. In many high-profile civil cases, the verdict marks the beginning of an entirely different phase. The attention shifts from proving facts to enforcing judgments. That transition is governed by a detailed set of procedural rules designed to balance two competing principles. On one hand, every litigant has the right to seek appellate review through the channels provided by law. On the other, judgments cannot remain indefinitely suspended. At some point, litigation must reach finality. Federal courts therefore place significant importance on procedural deadlines. Appeals are subject to strict filing requirements. Certain requests may pause enforcement temporarily. Others do not. Once those procedural avenues have largely been exhausted, judges typically turn their attention to implementation rather than continued debate over the underlying facts. This distinction is important because public discussion often treats every new filing as if it reopens the entire case. In reality, different stages of litigation involve different legal questions. A trial determines facts. An appeal examines whether legal errors affected the outcome. Enforcement addresses how an existing judgment is carried out. Each stage operates under its own standards. That separation is one of the defining features of the American judicial system. It also explains why procedural filings sometimes receive headlines that appear more dramatic than their actual legal effect. For lawyers, many of these documents represent ordinary litigation practice. For the public, however, every filing in a nationally known case can appear to signal a major turning point. The difference between those perspectives often fuels misunderstanding. Another aspect worth examining is the role of judicial discretion. Federal judges do not simply follow a mechanical checklist. Procedural rules establish the framework, but judges frequently retain discretion over scheduling, enforcement timing, and the management of complex litigation. That discretion is exercised within legal boundaries and remains subject to appellate review where appropriate. As a result, two cases following similar procedural paths may still unfold somewhat differently depending on their specific circumstances. This is one reason legal analysts often avoid making confident predictions before a court has issued its written order. Until a ruling appears on the docket, much remains uncertain. Public commentary may speculate. Legal filings may advocate, but the court itself speaks only through its official decisions. That distinction is fundamental. Another lesson from this litigation concerns the relationship between courts and public opinion. Modern legal proceedings unfold in an environment where news travels almost instantly. Court documents are analyzed within minutes. Television panels debate filings before opposing parties had even responded. Social media frequently compresses complex legal issues into short headlines. Yet courtrooms operate on a much slower rhythm. Evidence must satisfy procedural standards. Arguments must be supported by precedent. Judges explain their reasoning through written opinions rather than public statements. This difference in pace often creates the impression that the legal system is lagging behind public debate. In reality, the judicial process is intentionally designed to move more deliberately. The goal is not speed alone. It is accuracy, procedural fairness, and consistency with established law. Whether observers agree with a particular outcome or not, those principles remain central to the federal court system. For that reason, high-profile litigation often serves as a window into broader institutional processes. The individual parties naturally attract public attention, but the lasting significance frequently lies elsewhere. It lies in how courts interpret procedural rules, how appellate review functions, how judgments are enforced, and how legal institutions attempt to maintain public confidence while operating under intense political and media scrutiny. Those questions extend far beyond any single lawsuit. They influence future litigation involving businesses, public officials, private citizens, and organizations alike. Every significant procedural decision contributes, in some measure, to the broader body of case law that guides future courts. That is why legal observers often focus less on headlines and more on the language contained within judicial opinions. Written orders establish precedent. Media narratives do not. As this litigation continues through its remaining procedural stages, attention will naturally remain focused on future court filings and judicial orders. Some developments may prove significant. Others may simply represent routine procedural steps receiving extraordinary publicity because of the parties involved. Distinguishing between those two possibilities is essential for understanding the case accurately. Ultimately, perhaps the most important lesson is not about one plaintiff or one defendant. It is about the structure of the legal process itself. Civil litigation is designed to provide multiple opportunities for review, while also recognizing that disputes must eventually reach a conclusion. That balance between due process and finality has shaped American civil procedure for generations. High-profile cases inevitably test that balance in public view. They invite debate. They attract scrutiny. And they often become symbols of broader political or cultural disagreements. Yet beneath those debates, the legal process continues to operate according to established procedural rules, judicial precedent, and written decisions. For observers seeking to understand these cases, focusing on those institutional mechanisms may ultimately provide more lasting insight than any individual headline. Because long after media attention shifts elsewhere, the procedural principles established in today's cases may continue influencing tomorrow's litigation throughout the federal court system.